Hello, everybody. This is a new and exciting experience to be chairing a session in the conference like this. Usually, we are in Les Halles in a room somewhere. So, but this is new. This is 2021. So, welcome to the session with the title "I Spy with My Little Eye." Something beginning with F: Intelligence Agencies and Fundamental Rights. Now, what is the topic of today? I think in recent years, most people on this planet have become aware of the importance of data protection and privacy protection. And we see that there is a lot of concern about how Facebook treats our data and maybe even public authorities. But the one area that is still very much below the radar is the secret services, intelligence services, and they have been acquiring more and more powers. They get access to more and more data, and they can use it in more and more ways as we are moving into the era of artificial intelligence, for example. I mean, the possibilities have no limitations. And then the question arises, do we have sufficient oversight, and do we have sufficient remedies in case something goes wrong, and is there sufficient enforcement of all the rules, the safeguards that are supposed to protect our rights, and also do we have sufficient idea of who has access to our data? What does Brexit mean, for example, given that the UK is a member of the so-called Five Eyes and the Nine Eyes and other cooperation arrangements? So, in other words, what do secret services do with information on us? Can we actually verify that they stick to the rules? Because we have seen in recent years, in Denmark, for example, but also in the Netherlands, in Great Britain, that intelligence services and also law enforcement services tend to be fairly relaxed about the rules, or they interpret the rules in ways that they like. And it is very difficult for oversight bodies to exercise meaningful oversight, because there's, of course, always the tension between, well, secret services, which are, as the word says, supposed to be secret, and public oversight. So we have a fantastic panel here today to reflect on these questions. But first, some practical issues. This session will be recorded and can be watched afterwards at the CPDP website. If you have a question, you can enter it mentioning your name and organization where applicable. The person that you want to address the question to, put it in the chat, and then it will be passed on to the panelists. And 10 minutes before the end, you will get a signal that the panel discussion is almost over, so that we all move to our concluding remarks, because timing is very, very strict. So the three fantastic people on our panel today are, first of all, Jan-Jaap Oerlemans, who is the endowed professor intelligence and law at the University of Utrecht, from my own country. And he held his inaugural lecture in November last year at the University of Utrecht. And that was actually, I spotted that, and it was one of the reasons that we are doing this session. And the title of his inaugural lecture was Limiting Data Hunger, the Protection of National Security in a Democratic Rule of Law. He is also a senior researcher at the Dutch Review Committee for Intelligence and Security Services. And in his research, he focuses mainly on the digitization of the work of the intelligence and security services. So he is really the man on this topic. Then we will be hearing from Edin Omanovic, I hope I pronounced that correctly, who is the advocacy director at Privacy International. And he focuses on the security industry, surveillance technology, migration, biometrics, state hacking, border controls, sanction and export controls, intelligence agencies, telecommunications operators, and security aid. And I think that also indicates that this problem or this issue is not just about, strictly speaking, secret services. It is much more complex than that. And last but not least, Nico. Oh dear. Okay. which cannot be fixed in the meantime. Okay, that is highly unfortunate because Nico van Eyck is the chair of the review committee on the intelligence and security services since November 2019. So the supervisory committee of the Dutch intelligence services. Okay, maybe I can still hope for a miracle in the next 20 minutes or so. I mean, we are at the zenith of technology. You know, I would really hope that somebody finds a way to connect him. Excellent. Okay, I'm first going to give the floor to Mr. Oerlemans for, let's say, a maximum of 7 minutes. You have the floor.
Yeah, Sophie and Veld, thank you for inviting me. It's an honor to speak about well, surveillance and intelligence and security services. Like you said, I'm also very interested in the topic, and I research the relationship between fundamental rights and the work of intelligence and security services. But for my brief introduction, I would like to talk about bulk data sets. It was also a topic of my inaugural lecture in November this year, but I think it's a very suitable topic for this panel because you can also make interesting relations to EU law, which is also something that connects many people in this conference. So I will talk about bulk data sets, and in particular also bulk data sets that are acquired from airline companies. So what are bulk data sets? There are very large data sets about a set of individuals. And you can think, for example, of leaked registration information from websites. Sometimes big companies are hacked, and then their client database is basically sold or offered online. And intelligence and security services can use that kind of data in order to see what, for example, what email address relates to a name or what passwords people are using, and they can use that in their work, basically sometimes to verify identities, and sometimes they can use additional information for other intelligence methods they use. And these data sets, they can contain information of millions of individuals. There are also large data sets with passenger information from airline companies. And that's because airline companies are acquired to process data of people, taking a plane, mostly from outside the EU to an EU country, and now with PNR directive also within the EU. And that information is then transferred to competent authorities that can process the data for their own tasks. Well, and intelligence and security services are also interested in that kind of data. Because the data may contain people that threaten national security. With regard to airline passenger data, for example, you can think about how the information can be used regarding to the name, of nationality, birth of date, and information based on past travels. But also future travels, future travel flight information, such as the departure place and the estimated place of arrival may be important. Because, for example, for states, it's relevant to know when a known terrorist enters your territory. So then you can arrest that person, or you can gather intelligence by observing the information of observing the behavior of that person from that point on. So I think bulk data sets, they require our attention because it's characteristic that most people within those data sets are not targets of intelligence and security services. It may be information from you and me when we went on a holiday outside the EU and came back by plane somewhere in the past few years. In that case, your information may be processed and stored by intelligence and security services. And I think when you take in consideration relevant case law regarding the mass retention of DNA materials, for example, or telecommunications data, I believe the processing of bulk data sets to protect national security may be possible, and it may be considered as necessary in a democratic society. However, you need to regulate that properly within your national law. So national legislation should be accessible and foreseeable and dictating that intelligence security services can acquire the data and under which circumstances on a very basic level. I also think it should be public, the kind of law, and you should know whether state agencies actually have access to that kind of data. And in the Netherlands, we published a report about the use of airline company data. With we, I mean the Dutch Review Committee for Intelligence Security Services. And we basically said we consider that data as a bulk data set. The information was acquired by Dutch intelligence security services from the Dutch military police. And the Dutch military police is in the Netherlands tasked with combating migration crime and also terrorist crimes at the Dutch borders, so also at airline companies. And with regard to the possibility of Dutch national intelligence security services having access to that data, you have to look really, really carefully at legislative history to find that out. It's based on a very general power of intelligence security services to ask for information to companies or governmental institutions, and they voluntarily disclose that kind of information. And this really broad legal basis was used to gather the flight travel information from millions of individuals. And even in the Dutch implementation of the PNR directive, you know, the European PNR directive about passenger name records from airline companies, it is said that it's not explicitly stated that Dutch intelligence security services are competent authorities that have access to that kind of data. Other governmental institutions are said to have access to that information, but the Dutch intelligence security services are not explicitly mentioned. Again, you have to look in legislative history and questions to the responsible minister, and he will tell that Dutch intelligence security services may have access to that information, again, based on that really broad power to require this information on a voluntary basis. And of course, I think we should realize that Dutch intelligence security services are not the only agencies that collect and process this kind of data and treat them as bulk data sets. And what's interesting, I think, is that in the Netherlands there are some developments on this issue. Last week, an evaluation report was published about this topic, and basically the commission evaluating our Dutch intelligence security law said we need a specific legal basis for intelligence and security companies to acquire that data. So it should be mentioned more explicitly. They have the power to collect bulk data sets from other governmental bodies. You know, and that's a good first step, but I didn't see it say anything about further regulations. For example, how long can this data be stored? And what kind of data are we talking about? Should the governmental bodies be explicitly mentioned, or should it be this broad? And I think these are important and interesting legal questions that also apply to other countries. And I think, like I said, there's an interesting link to be made with European law, because we're talking about passenger name records and there's this PNR directive. But we should realize that, you know, historically the European Union does not have jurisdiction about issues relating to national security, because it's regarded as the competence and sole responsibility of member states to protect national security. However, in recent case law, and I'm referring to La Quadrature du Net and Privacy International, which is well known by Edin, I think, the European Court of Justice stated that there is an exception to that rule when European, in this case, the e-privacy directive was involved. So basically said in that case, we do have jurisdiction and they can talk about the legality of national legislation protecting national security. But the Quadrature du Net and Privacy International concerns telecommunications information and a different directive, the e-privacy directive. So this does not mean automatically that the case law can be applied one-to-one to the PNR directive, but they are, you know, similar in a way that it's about bulk data. It's about the processing of data of individuals that are not actually targets of national security and intelligence agencies. So in this way, we'll see in the future, perhaps the European Court of Justice may apply a so-called adjudicative jurisdiction and set important boundaries in the future. So it will be very interesting to see whether that will happen or not. So to conclude, I think there are really interesting questions relating to the legality of the collection and processing of bulk data sets. And I use the example of flight information that's processed for national security purposes. And ultimately, I think that case law may lead to stricter requirements to process this kind of data. And I think that's important and that's desirable, because then you can also have more harmonization of data protection with regard to this data within the EU. I'm not too hopeful that the EU can regulate these kind of activities, because again, the EU doesn't have jurisdiction regarding national security, but we can expect some things about that from case law. I just wanted to say also, when we harmonize law, that won't be enough. You need to have proper supervision of that law, and of course supervision authorities have to cooperate in that enforcement of national security law, but because it's such a national regulated business, you can say, there is not much supervision. And that has to do, of course, with the very sensitive and secretive field we're working on. If you say that supervisory authorities have to cooperate, they need to share sensitive, secretive information. And basically, just about all supervisory authorities are not authorized to do that. And I think the first step is then to have also on a national level a discussion about that, and perhaps give the power to share secretive information. And then, for example, you can have supervisory authorities do research together into bulk data sets, and for example, those airline company information. I haven't seen steps in that direction in the recent years, but I'd be happy if you could prove me wrong. And additionally, I'm of course keen to hear whether participants have a different view regarding the case law relating to national security, or the relationship with the EU law, and other suggestions. So I look forward to the discussion we'll have later on.
Thank you very much. I am not going to give in to the temptation to now say a lot about PNR, which is my pet topic, and I think we are must be March. I think we're coming up to the 18th birthday of PNR being on the table of the EU legislator, but I'm sure we're going to come back to this. Two remarks I would like to make, takeaways from your introduction before we go to Edin. One is, as you rightfully mentioned, is the difficulty to exercise meaningful oversight, in particular when we are talking about increasing cross-border cooperation. Now, I'm in favor of cross-border cooperation, but what we see here is that the fiction that national security is a purely national competence and therefore, Europe has nothing to say about it, that fiction is being upheld, but it's nothing more than a fiction. Because if I see the entire body of legislation that has been passed over the last 20 years or so, referring to national security as a not strictly a legal base, but as a justification for European, let's say, common action, it's very obvious that national security is fully a European competence by now. But they're always hiding behind that argument when, they take action, they make legislative proposals for all sorts of measures, fighting terrorism, mass surveillance, what have you. But then when you argue, yes, okay, but then we need, a proper European intelligence arrangements and proper oversight and European safeguards, then they say, no, we can't, because, it's national, we have got nothing to say. And there is a huge gap which I think is a big risk, because already at national level, strictly national level, exercising meaningful oversight is a challenge at any given moment. Even in countries where the legislator is really sincere in the wish to apply all the safeguards, and of course that is not the case everywhere. And I think there's very little incentive for national authorities to apply safeguards to citizens from other countries. So those are two remarks that I would like to make. Now I'm passing the floor to Edin Omanovic from Privacy International.
Yeah, thank you very much, Sophie, and thank you for inviting me today. I'm calling in from London, and I think what would be most useful in these introductory remarks is to stick to the issues we face in the UK. And while they're specific to the UK, they're not unique. So these are issues faced across by European citizens. And I want to focus on what I think are three major problems and then three potential solutions that I think we're experiencing. So to provide some context, as you may know, the UK is we've left the European Union. So we're currently facing an adequacy assessment, which should be finalised by the middle of this year. We're some years into the Investigatory Powers Act, which legalised some of the most extreme surveillance powers in the world. And yesterday, we were in court to try and place some meaningful due process and limit some of the crimes that agents of intelligence agencies are allowed to carry out. Because at the moment, they're allowed to do things like commit rape, torture, and murder. So that's where we are in the UK. So the first problem I want to focus on is mass surveillance. I don't think there's getting away from that. So this is something we've challenged through the courts and through advocacy. In 2018, the ECHR, in one of our cases with 9 other human rights orgs, found that the UK's mass surveillance powers were unlawful because they weren't restricted to what's necessary in a democratic society. And this is consistent with CGEU judgments. So, for example, the one in October regarding the general indiscriminate collection of communications data, as Duke mentioned, and the fact that national security exemptions couldn't be used to essentially undermine fundamental rights protections, and the findings on proportionality in Schrems 1 and 2. So the solution for us is quite clear, is that these mass surveillance techniques just need to end. So we're taking a case at the Grand Chamber now of the ECHR, calling for them to just rule bulk collection itself as unlawful. On top of that, obviously, you do have things like safeguards, which I think as people who follow the intelligence agencies are beginning to kind of understand what good safeguards are and what best practices might be. So things like actual judicial authorization, things like oversight bodies having technical expertise, being able to actually get information from the intelligence agencies. So some good practices developing there. And then other things that might be used as solutions. So the promotion and use of strong encryption. So if a company is transferring personal data abroad, if it does things like ensure the data is end-to-end encrypted, then intelligence agencies can't just come in and demand access to it. So those are some potential solutions. Second problem is intelligence sharing. This is something that multiple NGOs and FRA has also recognised, highlighting the urgent lack of legality, transparency and safeguards when it comes to intelligence sharing. So obviously the UK, we're part of the Five Eyes and we share intelligence by default, yet we still rely on a real arcane set of international agreements which provide no meaningful safeguards into how this takes place. And the risk here is obviously that these intelligence sharing agreements can be used to sidestep international national protections. So again, as part of the 2018 ECHR case, the judgment found that intelligence sharing itself was essentially the same as carrying out direct surveillance. So that would mean that there need to be equivalent safeguards to that activity. And across Europe, you have intelligence sharing by the intelligence agencies themselves. It's very prevalent. So while EU law more explicitly regulates law enforcement sharing, you have intelligence agencies, for example, the SIG and seniors, the countries which have access to submarine cables, cooperate with other intelligence agencies, including the US NSA, so Sweden, Norway, and most recently this was highlighted in a case in Denmark where a whistleblower highlighted some abuses that were occurring there, and that's led to investigation in Denmark regarding a program known as Rampart A, whereby the NSA provide countries with equipment as long as they get access to some of the intelligence. Yeah. And the solution to that is transparency on some of these agreements. So it's, again, like I say, we don't really know the extent of that cooperation. And then cooperation among the oversight agencies themselves. So whereby you do have some parliamentary or other committee that's able to oversee the intelligence agencies, they need to be able to share that expertise and share best practices among each other and cooperate, and to do things like share their understanding of the technical issues that they're seeing. And then to also use some of these positive practices and share them with third countries. So at the moment, the EU and European member states share a lot of expertise when it comes to surveillance and legal powers that are used to justify surveillance and surveillance technology, but we've not seen the equivalent sharing of good practices. So this has led to a situation whereby the states in the periphery of the EU are empowered with surveillance powers, yet there's not an equivalent export of protections. And the third problem, I think, is really political, and it's the fact that as long as a capability exists, history has shown us that intelligence agencies will try to exploit it, and that's really because that is their job to do so. But it's the job of politicians to really try and put some limits on this. Unfortunately, at the moment, what we're seeing in Western Europe is that the political cost of putting limits on this is really too high compared to the long-term necessity of protecting freedom. And politicians are far too eager to just sign off and give the intelligence agencies powers because of this mantra that it's the first duty of government to provide security. And while that is very much true, the problem here is that the definition of security is very narrow, and it's very narrowly defined around national security. And I think this has been something that's been brutally exposed by the pandemic. So for example, in the UK, we're one of the world's leading economies. We have some of the best universities in the world. Our intelligence agencies and other law enforcement agencies have all the powers and technology they need. Yet we've just passed over 100,000 deaths of people for the year, because we were completely unprepared for a pandemic that we knew was possible and that we knew was coming. So I think we really need to ensure that some of the energy, money, and other resources that are being spent on national security and powers to intelligence agencies are instead focused on realistic security measures. So things like making sure pandemics don't just wipe hundreds of thousands of people out, things like preventing the climate crisis. And what that takes really is political leadership and political bravery that's driven by public engagement. And that's, I think, if there is a silver lining of the year we've gone through and the pandemic, it's hopefully that people are moving towards this realization that we need to move in that direction. Thanks.
Okay, thank you very much. I think in the meantime, they're still attempting to bring in Nico van Eyck, but in the meantime, we will kick off with the questions. I would like to, we're already receiving some questions, but until I call the first one, I would like to ask you, Edin, you did have some legal victories against the mass surveillance programs, or let's say the very invasive powers of the intel services in the UK. Do you have the feeling now that oversight has also been strengthened? Do you have the feeling that the oversight bodies are sufficiently, let's say, alert, aware, critical?
So I think certainly when compared to what happened before the Investigatory Powers Act, it is an improvement, to be fair. When it comes to the Parliamentary Committee, we've been dealing with Brexit, with the pandemic. I struggle to see how they can provide effective oversight just because of their limits on their resources and lack of kind of technical understanding of what the powers are. And really, I think we don't know what they have access to, what information they're able to see, and then how they're able to hold that to account. We have an oversight body now, the IPCO, which has conducted audits of the intelligence agencies and which has, in a number of instances, found abuses and unlawfulness of the intelligence agencies, which depends on how you view it as either a good or bad thing. So I certainly think there's an improvement. But ultimately, our legal cases were driven by the fact that we uncovered this information as a result of some of the Snowden documents. So we're still advocating and litigating powers that were revealed by Snowden, some of them from the mid-2000s, and which were subject to laws that were around then. And since then, we've had the IPA. So it's been very easy for the intelligence agencies and government to say, well, now we have this new IPA, so all the issues are resolved. Yet, because we don't have transparency, we've got no way of knowing if that's true or not.
Okay, I hear some noise in the background. Okay, thanks. And maybe one more question to Jan-Jaap Oerlemans. In the Netherlands as well, there's been a kind of, let's say, modification to the, or a strengthening of the oversight bodies not so long ago. In your view, is it now effective enough? Can it exercise meaningful oversight? And do you see any attempts to, not just the intelligence community to work together across borders, but also the oversight community, if I may say so? Can you say something about that?
Sure. Yeah. So since May 1, 2018, we have also a supervisory body that has to give prior authorization to many of our what we call special powers, but you think of bulk interception or hacking or normal interception. And I think that's really important. It's a really important safeguard, and they have it's a binding authorization. So if they don't give authorization, they cannot do it. And that's also, I think, the way it works in practice. That's what we can see, and it's also what you can see of the public reports that the other review supervisory authority, the review committee on intelligence and security agencies will report on. So I think it's a very important safeguard, and I think basically it's also required by some fundamental rights. When you talk about bulk interception, the ECHR, the European Court on Human Rights, said in Big Brother Watch that prior authorization should be there, and it should be judicial, and if it's not judicial, it should be made by an independent authority. So definitely it's a good thing it's there. I think it's also clear that the prior authorization committee and the review committee work together. There are many meetings they have. They talk about how to interpret the new legislation. I think it's basically going fine. What we don't have in the Netherlands, for example, is binding powers to stop unlawful processing of information. And you see those binding powers at the authority that has to oversee the normal processing of personal data, the data protection authorities. And you see it also with the processing of police data. but we don't have that in the intelligence and security agencies in that field. So I think that's a discrepancy, and there is discussion whether those binding powers should be there. When you see the recent case law of Privacy International and La Quadrature du Net, the European Court of Justice does mention that again and again that binding review powers are required, but it doesn't really detail what that means. But there's another really interesting development going on, and it's a treaty of the Convention on Europe on the processing of personal data. It's being modernized. The treaty is called Convention 108, and it's being modernized so that now there will be a new convention, Convention 108 Plus. And that convention gives stricter requirements of states that ratify that convention, and the requirement says that the basic principles of processing information also apply in the national security field. And those basic principles should be implemented in legislation. And it also says some things about supervisory authorities, like they, for example, they should have binding powers, and if not, a state should explain why that won't be necessary in a democratic society. And I think it is necessary. So that's an interesting development, and it's interesting to see how states will deal with it, and hopefully it will bring some more harmonization in how states regulated oversight on national security law.
Okay, thank you very much. Indeed, Convention 108 is a very important one. Tomorrow there's another CPDP session dedicated to that, on which I have the honor to speak as well. But indeed, it's there has to be a kind of, if there is cross-border legislation, EU legislation on essentially national security, then there should also be cross-border binding rules on oversight and how the safeguards can be made meaningful and not just paper safeguards. I have a question by Monica Ermerts, but she doesn't indicate to whom. A question about the decryption platform, which is planned for Europol. And she asks, is it another example of sharing intelligence, defying the national competence standard? And in other words, because Europol is supposed to be law enforcement, but law enforcement and intelligence, there's no Chinese wall anymore between them. And how would this fit into Commissioner Johansson's recent announcement or commitment to no weakening of hard encryption? Of course, that's for Commissioner Johansson to respond to, but maybe you can share your views on that. Maybe Edin first.
So I mean, Europol is just one of a number of agencies which are demanding some form of exceptional act. Install weaknesses in their encryption code in a way that doesn't undermine security for everyone.
Sorry, Edin, to interrupt you, but you were, I think there was a little break in the connection. Okay, sure. At least I missed the part.
I'll start. Yeah, so Europol, so in addition to them, you also have, for example, the Five Eyes interior ministries that are pushing for some form of what they're calling exceptional access. You have national intelligence agencies that are like the FBI that are calling for some form of exceptional access, and what they want is just scientifically impossible. They want exceptional access for them in a way that protects everyone, which just isn't really possible. The long-term view of this is that these agencies have been calling for these powers forever, yet at the same time they've now got more access to more data, to more intelligence than they've ever had. So the entire going dark debate, the entire debate around them needing access to these encryption devices, I feel is completely unfair given the history and trajectory of how much intelligence they've actually had access to.
Okay, thank you. In the meantime, I get the sad news that Mr. Nico van Eyck will really not be able to connect anymore due to the bad quality of the sound connection. In the meantime, I do have another question by Sophie Oerlemans for Edin. She says, I'm a PhD candidate at the University of Utrecht. I find your take on national security very interesting. Thank you for your explanation. In light of increasing cyber threats, do you regard cybersecurity as a matter of national security? It therefore partly being a task for the intelligence and security services, or do you regard it as a matter of realistic security and something that should not be handled by intelligence and security services?
Yeah, really good question. I think generally the history of intelligence agencies, we have to understand, comes from this kind of almost bygone era where they have to protect certain information from certain other people. And as a hangover of that, they've now managed to increase their competence in areas which could very easily be given to civilian agencies and to law enforcement agencies. So we always have to question, the first question should always be, why is a secret intelligence agency carrying out this task over a civilian one or a law enforcement one? And cybersecurity is definitely something that other agencies can and should take competence of. There's no reason for it to go to intelligence agencies. In the UK, what's happened is that all the resources, all the expertise has been given to the intelligence agencies. So obviously they're the best ones when it comes to understanding the cyber threats out there, understanding advanced exploits, understanding vulnerabilities, understanding how to harden networks. So it's these intelligence agencies that have been doing that. Most recently, there have been some positive steps in breaking off the defensive part of our intelligence agency and making it a national cybersecurity centre, but it's still formally part of the intelligence agency. So you have the situation where you have the defensive side, which was for cybersecurity, being led by the same minister that is in charge of intelligence agencies, which is conducting offensive operations. So these two things are at odds with each other. So it should certainly be the case that cybersecurity agencies should be completely separate from intelligence agencies because they carry out completely separate tasks.
Yeah, I think more generally, as I said, the Chinese walls between intelligence and law enforcement seems to be crumbling, which is problematic because different rules and different safeguards apply. And I note in this respect two examples. One is that there is a big debate at the moment about a derogation to the e-privacy directive in order to fight child sexual abuse online. And this is being pushed very much by the Five Eyes, which I find remarkable because I think fighting child sexual abuse is a task for all of us, but I don't really see why that would be a matter of national security. And something else is that, of course, increasingly we get the feeling that public health is now declared a matter of national security in a way, and we already see quite unregulated data sharing of health data, maybe with the best of intentions, but still unregulated, without oversight, without legal base, so very problematic.
Can I respond to that, Sophie?
Yeah, sure.
Yeah, because I do think it's very different based on the different states because it's not harmonized. National security legislation and the powers they have, the tasks they have. There are very big differences depending on the country we're talking about. So in the UK, the intelligence services indeed have also jurisdiction about serious organized crime and things like child pornography. In the Netherlands, there is a clear distinction in that because those will be things that law enforcement picks up and not security and intelligence agencies. In the Netherlands, it's much more clear that the intelligence security services have tasks when there's a threat to national security. So it will be about terrorist attacks, it will be about counter-espionage, those kind of things. And also relating to responding to the questions before, and when we talk about cybersecurity, of course, cybersecurity can endanger national security when it endangers your economy or when you think about espionage by Russian or Chinese authorities, then intelligence security agencies are equipped to counter that kind of espionage and collect information themselves about those espionage activities. And they have broader powers than law enforcement agencies, and the information they collect is not easily transposed in the criminal procedures, for example, in the Netherlands. So I think there's a distinction between national security and law enforcement. I do not agree that it's not clear anymore. I think it depends on the country we are talking about. So yeah, I think that's important to point out.
I'm going to disagree with you, which is good. That means we have debate. The point is that would be true if you apply that logic to a single country, where they may or may not have a proper definition of what is national security and what is law enforcement. I would dare to say that in many countries that is not entirely clear. The point is that, as I said at the start, there's really a raft of legislation that has been passed certainly over the last 20 years, which has for objective protecting national security, whereas that is not a European competence. But the point is, there is no European definition of what national security is. So that means that given that in the area of national security there are weaker safeguards and there's weaker oversight, if you don't define what that area is, then it's kind of, you can label anything national security and all of a sudden the safeguards don't apply anymore. And I find, for example, the fact that Five Eyes, which isn't even strictly, well, it's now actually almost strictly outside EU, but they are pushing for European legislation on allowing, let's say, massive screening of content, of messages and what have you, and other activity detection of possible potential material. So weakening safeguards, it's very invasive. It's pushed for by intelligence services. It's European legislation. But if it's national security, then weaker safeguards apply. I find this extremely problematic, I have to say. There are three more questions. One is about PNR, which we will keep until the end. One is by, I'll put them to both of you. The first one is if you have any insight on how scandals involving intelligence agencies abusing their powers, getting access to more data than they're entitled to, etc., overstepping their powers, how they are being perceived by the general public and what the differences are between the member states. And the second question is by Peter Swire. He asks about the process announced by the OECD to create principles for government access to commercial data, including for intelligence purposes. Okay, and there are more questions coming in, but maybe you can both answer to these two questions already. Maybe Jan-Jaap first.
Well, I was triggered by the question of Peter Squire, but honestly, I haven't read that new proposal or regulation, so I will be very interested to read it. I think there's like my story was about PNR data and how it's relating to EU law, but still gets a national implementation of that legislation. In the Netherlands, national security agencies have their own access to it. But when you talk about gaining access to commercial data, I think there may also be an interesting relationship with EU law, for example, regarding telecommunications information or the GDPR. And because of the recent case law, I think the European Court of Justice may also apply their adjudicated jurisdiction and case laws develop. So I think that's a good thing, because then you can harmonize the kind of stuff. And when European legislation is made, it has to meet the European Charter of Fundamental Rights. So it should be taken in consideration when national security agencies also have access to that data, and what requirements apply and meet. And it should just, I think it's just part of the legislative process. It should be taken into account. We touched upon also, for example, the healthcare data, whether national security agencies have access to it. And I'm glad that in the Netherlands there was a debate about it, and they said no, national security agencies should not have access to the telecommunications data that's being stored to monitor movements in this during this pandemic. And other states take different decisions in that, and that's viewed as part of their sovereignty to do so. Regarding the first question, I can't remember what the question was, so I need to.
The other one was the OECD. Yeah, and whether these scandals. No, so OECD you replied to. The other one was whether you can see if these scandals have an impact on public opinion and if there is a difference between member states.
There's definitely a difference between member states. You know, how states approach their national securities, what powers they give to their national security agencies is greatly influenced by, you know, cultural and historical reasons. And I think they respond differently to it. In the Netherlands, due to the Snowden revelations, there was a debate coming up, and I think it's good that the debate was there. It led to more stringent requirements to the national security legislation. But if you see the most current debate, it's not about privacy and the scandals, if you say so, but the more about how can we still make legislation that that's loosely translated, it's workable. Like you can still do your work effectively when there's stringent regulations, and that's what the debate is coming up now in the Netherlands. So you see, it's going to a different direction, and maybe we will see that too at the different states. So it greatly differs on states, and I find it difficult to say so what it will be in a year or so.
Okay, Edin?
Yeah, I think that's completely right. It really depends on the country. So some of the recent examples, the fallout from Snowden was obviously very different in the UK, given the social and historical factors here, as it was in Germany. I think generally people care about stuff that they understand and that affects them. So, for example, recently people have actually paid a lot of attention to things like data sharing by WhatsApp, things like what Facebook is doing, because these are things that they use every day and that they can grasp. Whereas when we talk about intelligence agencies and bulk collection, bulk data sets, communications data, these are just things that nobody really experiences in their everyday life. So they feel as though it's very removed away from them. So we get a situation where people are concerned about perhaps WhatsApp sharing data with Facebook, yet are completely happy about bulk interception, where all metadata is continuously being intercepted all the time. So I think it really does depend. I think some positive examples have been, for example, in Macedonia, where we had a scandal a few years ago, in North Macedonia, we had a scandal a few years ago where the intelligence agency was wiretapping around about 20,000 people. And that was because the intelligence agency itself had operational control over the interception devices, so the wiretapping system. And that led to moves to try and separate the operational control of the interception system away from the intelligence agency. So whereby if the Prime Minister has hired his family member to be head of the intelligence agency, he can't just order him to wiretap anyone, because it has to go through another authority. So, for example, that move has been quite positive. So it really depends on the country.
Yes, yeah, hiring a family member to the intelligence agency. Okay. Yeah, there are more questions here. Well, let's go back to the one on PNR from an unknown person to Jan-Jaap, but I actually feel inclined to reply to it myself. It says, in the absence of a clear and compliant legal framework imposing an obligation on air carriers, do you know on which GDPR legal basis air carriers voluntarily disclose passenger data to intelligence services in the EU? In other words, is such voluntary disclosure lawful at all under EU law? The point is there is an obligation. There is a directive, the EU PNR directive, obliging carriers to disclose that information to European authorities. And we also have these international agreements obliging them to disclose or share that information with third country authorities. And these agreements are extremely problematic, also from a legal point of view. And that brings me to the question of Monica Ermert, the second question, who says, NGOs, politicians, activists have filed constitutional complaint after complaint, but governments, like the German, for example, with Intel law, just tweak legislation and make them go to court again. Where is there light at the end of the tunnel? Monica, I cannot tell you that. We are, I'm also, again, a party in a lawsuit against the PNR directive, as are many other parties and organizations. And indeed, you're right that every time you score a little victory in court, then they come up with something new. And it is really, it's clearly, we're living in a political climate which is not very favorable to a balance between powers for the authorities and legal safeguards for citizens, or indeed requirements for the authorities to be transparent and respect certain rules. And in this, the topic of today's session, intelligence services, it's incredibly difficult to verify, even if there are rules, if they are respecting the rules. But maybe about the litigation, maybe Edin, you could say something.
Fine. I mean, I think if you look at the long-term progression of where we've come with oversight of the intelligence agencies, it is positive, and it's very easy to kind of get swept away in like a lot of some of the negative stories and negative news. But things are improving, and that's because people are trying, like activists are trying, politicians are caring about this stuff, and the public are becoming more aware and more engaged. So the long-term progress, I think, is there.
Okay, Jan-Jaap, Oerlemans?
Yeah, no, I agree. I think there's case law is really important, and it's really important that there is litigation going on. And I'm highly interested in the new Big Brother Watch case coming up, hopefully in a couple of months, and see what the European Court of Human Rights, what qualitative requirements they set on national legislation if the state authorities conduct bulk interception. And it's highly influential. And yeah, I'm not sure if the balance is gone or it's really important we have intelligence security agencies to protect our national security, and they have the most far-reaching powers in order to do that task. But it does mean they have to take consideration have to meet the minimal requirements that international treaties or international courts set. And many things can be improved, and I think litigations helps little by little to get it improved. And personally, I hope in the Netherlands there will be some more litigation also about our national security law, but we'll see about that.
I'll tell you about my own personal experience. I've been litigating in the US, and I've started a case almost 5 years ago in France, and it's now before the court in Strasbourg on mass surveillance, and basically it doesn't get you anywhere. As an individual, I mean, there's just no effective remedy. There isn't. If you take on the system as an individual, it doesn't work. And I also think this blind trust in the safeguards and rule of law, I think again, if you're an individual, and now in my case, I'm litigating to trigger case law, to test the system, etc. But there are also people who are affected, who are, for example, falsely suspected of being a terrorist or a criminal or whatever. And there is no effective remedy in practice. And that is, I think, highly problematic. And we've seen in the Netherlands a case that even brought the government down a couple of weeks ago, whereby the fiscal authorities were asked by politics to crack down on fiscal fraud with child benefits. And they took it very seriously, and they used methods like ethnic profiling, and people were falsely labeled as fraudsters. They had to pay tens of thousands of euros to the tax authorities, and they were basically ruined. Their lives were ruined, their marriages, they lost their jobs, they lost their homes. And then you see those people have been litigating. But if the system says, no, we have to protect the tax authorities, or as you say, we have to protect security, then it becomes very difficult, very, very difficult. And the more these intelligence services or law enforcement or other authorities can use our personal data, and even for predictive purposes, the more unprotected we are against abuse, mistakes, arbitrary application, and what have you. Hang on, we have just a few. We have to round up. We have 5 minutes left. There was one more question that okay. Give me 1 minute for the last question. Yeah, we also started late. The last question by Debray Kennedy Mayo. How do you reconcile the lack of EU-level requirements and oversight for member states' intelligence agencies and the strict new requirements that Schrems II expects to be imposed on the intelligence agencies in third countries like the US, Australia, and China? Very rapidly, first Jan-Jaap Oerlemans, and then Edin, and then we wrap up.
Again, from a legal perspective, national security legislation is the sole responsibility of member states. So when Schrems was about commercial information, and basically the third country, that the NSA doesn't meet the same requirements as in the Netherlands or as in the EU, and therefore you cannot transfer the data the way they did in that agreement. It doesn't affect national security legislation directly. From a judicial perspective, you can disagree with and say it's not desirable, but from a legal perspective, it can be perfectly explained, I think.
Mm-hmm. No, but I think the question was more that we almost seem to have stricter requirements when it comes to scrutinize whether third country intelligence services meet our standards, yes or no. But I'm quickly going to go to Edin because I'm conscious of the time.
Yeah, I don't really think you can. I wonder how many EU member states would pass an adequacy test themselves. And essentially what that highlights is that the rule of law and these standards are being held hostage by intelligence agencies that just don't want to hear it, they don't want to listen to it.
No. Okay, we have to wrap up, unfortunately, but I would like to thank you very, very much. I think it would have been wonderful to also have Nico van Eyck, because I'm sure that he would have liked to respond to many of these issues. But it's been very enriching and educational, as always. So, Mr. Oerlemans, Mr. Omanovic, many, many thanks. And I hope to the viewers out there that you will enjoy the rest of the conference. And I hope to see some of you again in tomorrow's session on Convention 108. Thank you very much and have a nice afternoon.